Well, good morning, everyone. We're going to go ahead and start. This is Jeffrey Lynn. Thank you very much for joining us. This is from the law firm of Beighley, Myrick, Udell Lynne. And for those of you who may know us, we represent treatment providers, recovery residence providers, anything having to do with the recovery and treatment spectrum across the country. And we're really, really proud and pleased to have brought on to our firm Thomas or Tommy Zeichman, who does restructuring, bankruptcy, things dealing with how to deal with the economy of your business when things aren't going so well. Most people think they just have to close up shop or that they're in debt and that they're, stealing from Peter to pay Paul. There are a lot of legal options that you have. And those legal options are things that is directly in Tommy's wheelhouse. So let me just talk really quickly about Tommy. He's a local. He went to FAU and Nova for law school, and his life since law school has been deeply entrenched in this very topic. He represents debtors, creditors, and trustees in all aspects of bankruptcy and in restructuring and other kinds of matters. He's represented purchasers and sellers of distressed assets through bankruptcy, receiverships, assignments on behalf of creditors. He's represented creditors and bankruptcy trustees in pursuing assets of debtors, which happens frequently in this space when someone is going out of business and you have an opportunity to go after their assets to grow your own platform, or vice versa, talking about what is the value of your asset? What's the value of your business? What are you trying to sell if you have a drug and alcohol treatment center? And are what are issues that are going to pop up along the way that you could attack or prevent as opposed to just letting them eat you alive, especially these days? Tommy is AV rated preeminent by Martindale-Hubbell, which is a legal rating agency, which means he is top of class. And he's been recognized by Florida super lawyers as a rising star in bankruptcy. And with that, I'd like to turn it over to my law partner, Tommy Zeichman. Tommy, take it away. Let everyone know what's going on out there in the world of restructuring and healthcare.
Thank you, Jeffrey. I appreciate the introduction, and I appreciate everybody that's tuned in to watch us and go through this. And as Jeffrey mentioned, at a point in time, a lot of bankruptcy and restructuring had this stigma of it's the end. But for many people, it's the way that they emerge stronger, or it can be a buying opportunity if you've positioned yourself in such a way to do that, and you can get a lot of protections through those sorts of sales that you won't see elsewhere. We do want this presentation to be interactive. Um, so there is a question and answer feature on Zoom at the bottom of your screen. And there we go. We have a little bit of movement. At the bottom of your screen, you may have to scroll over it with your mouse. There should be a raise hand or a Q&A feature. If you have any questions throughout this, just go ahead and ask them there. We do have a question and answer at the end, but I told Jeffrey before we started this, when I'm talking to judges, they don't wait till the end until I'm done making my point. So go ahead and ask your questions. Jeffrey's going to review them, and we may ask them while I'm speaking as well. I do want to keep in mind that this is a webinar, and we're not, there's not an attorney-client relationship right now. If I'm answering your questions, some of them may be more personal, and we'll think about that. But there are good questions that you may want to ask as we're going along. Your case will be very specific, and we'd want to check that out. Nobody's financials are exactly the same, or goals are exactly the same. So with that, we'll go ahead and get started. And the first question that's usually asked in these is, are you wearing a full suit? And I'll go ahead and get that one out of the way. And the answer is yes, because enough judges have a sense of humor and have started asking attorneys to go ahead and stand up and show their full wardrobe. So I erred on the side of caution if that question was going to be asked. So let's go forward. Why do companies restructure? And that term, it's not a common term that we think about, but restructuring is the overarching process of how you modify your debts. Whether it's, I have a balloon payment coming up and I need to stretch the terms over because it would be really helpful to me if I could pay a set amount each month or quarterly or things like that, and getting that agreement or a court order forcing your creditor to take that option. In this case, we're kind of under this unprecedented times where there's a lot of uncertainty. When there's uncertainty, unexpected things happen. And some of those unexpected things that happen, for instance, let's say you just bought a new building and you were going to grow your company. You have your financing in place. You know that you have patients that are going to be interested in visiting this space, and you hire a construction company, and they're going to make it beautiful. You're going to be a top shelf provider. But then that construction company has 5 other jobs where people stop paying them, and that deposit you put down, they no longer have it, and they stop your project, and it's more expensive. That's the type of hiccups that can come across here that you may not be expecting, but we're in that time of uncertainty. For behavioral health providers, some of the ones that have had to restructure, they cite new advertising restrictions that have affected their income. Also, dealing with insurance companies can be a trying process, to put it mildly, and they may slow pay on reimbursements. There's higher deductibles, and also sometimes it's just litigation. You get into a fight with your landlord. That can become very costly with some of your vendors, or fights between business partners all of a sudden can put a business in a tough spot. So those are some of the causes. But then, companies also look at, well, there are a lot of nice things that I can do in a restructuring. Certain debts, you can just wipe them out entirely. You don't have to pay them, or you pay them pennies on the dollar. Other ones, like we're talking about, you can stretch them out, and we're going to explain that process. And then for others, it's the ability to sell assets. And you may be thinking, okay, I have a good idea of what my assets are, but there are a range of assets that you may have that you can figure out through this process how to really make some money on them, even if there's liens and there's other creditor issues. You can modify that so that you can walk away with some of those proceeds, or you can buy them out with a lot of protections. So we'll keep going. During this talk, we're going to talk about the different chapters of bankruptcy. You may have heard chapter 7 and 11. We'll explain those differences. I'll explain some of the common issues that arise in bankruptcy. Also, many times a bankruptcy isn't necessary. It's, for me, a last resort. A lot of times my goal when we come in is to get a hold of what the financial problem is, if it's revenue, if it's cost, if it's one noisy creditor or vendor, or one particular lawsuit, and see if there's ways to work it out outside of an actual filing. And then there's also a state court proceeding, assignment for benefit of creditors, that a lot of owners have found very, very useful to keep doing business going forward. Healthcare involved restructurings, there are a lot of players. You have the unique ones, the patients and your physicians. The government may be involved, insurance companies are involved, and then you also have the traditional players that are involved in every case, your landlords, your banks, and you can deal with those. Healthcare providers also have a unique challenge that the cases have figured out a way to deal with, and that's the sensitive patient information that you may have in your possession. When you're trying to walk away, or if you're trying to do a sale, or if you're trying to restructure, there are ways that you can continue to protect that information while also sharing some information with buyers, or proceeding through these. So they're just because or if you simply want to walk away to go into a new venture, there's ways that we'll get into of how you can dispose of that information with a court order that'll help you out. We'll go over the differences and some of the common things in all bankruptcy cases. One of the first things is you're going to have to prepare documents that show all of your assets, all of your liabilities. It's filed publicly. If there is that sensitive information, we can redact it and protect that. But this is in federal court, and you go ahead and file it. And a Chapter 7 case, like it says on the screen, is a liquidation. The goal is to sell the assets, distribute them, the proceeds to the creditors. They get what they get, and you move forward. Now, one of the decided downsides of a Chapter 7 case is that a bankruptcy trustee is appointed, and they immediately take over ownership of and control of the business, and their goal is to simply wind down, sell off those assets. And one of the problematic ones, and why I don't, generally people do not recommend business Chapter 7s, is that one of the things a trustee can look for are lawsuits, and sometimes they'll look backwards at the directors and officers. I can only think of one case that I filed that was a Chapter 7 business bankruptcy case, and it made sense there, and I think it would be viewed as a successful case, and that was the Plantation Fashion Mall down in Broward that some of you may be familiar with. But that's a unique case. The more common scenario is a Chapter 11 reorganization. That's what you're seeing with Neiman Marcus, for instance. JCPenney just filed one. GM. Again, that's a federal proceeding, but what's nice about it is you remain in control of the business during that reorganization process. And you have a lot of very powerful tools. This is where you can force creditors to take deals that they may not otherwise want to take. Stretch debt payments out. You can reject some leases that are particularly harmful and not be obligated for those debts going forward. And there's some really powerful sales tools that we'll go over. Unfortunately, for a period of time, Chapter 11 had become so expensive and so slow that only the largest companies found it to be useful. But in the last year, Congress passed a law, the Small Business Reorganization Act, as well as the CARE Act, that kind of put that act on steroids, that actually makes Chapter 11 cheaper and faster and more powerful for small businesses. And we'll get into that later. One of the kind of just basic reasons that people file out of the gates is what's called the automatic stay. Usually you're getting inundated with creditor calls. You may have a lot of lawsuits. You may have a looming eviction, and you just want it to stop so that you can take a breath. And what happens as soon as you file a bankruptcy case is you get what's called the automatic stay. It pauses all of that other litigation and gives you an opportunity to sort everybody out in one place. I'll tell you, I've had cases where I have everything prepared to file if I need to, and I'm in court and we're arguing and we get a feel for the judge if we're about to get a judgment entered against us, and the second before that judge enters, I'll shoot a text message to the paralegal that says, "Hey, hit the button. We're filing." And I'll tell the judge, "Stop. You can't go any further." They don't love it, but they recognize that that's the power that's here. And this does stop most things, evictions, and then at most civil actions where they're pursuing your assets. There are some courts that are split on whether these key tam, your whistleblower, government enforcement things, sometimes that comes into play when you're dealing with the anti-kickback issues. Some courts have found that those stop, others have allowed them to proceed, or they force them to proceed in bankruptcy. One of the other really powerful things that you can do, it may or may not be applicable, are when you have Medicare and Medicaid provider agreements. There have been some really positive recent bankruptcy cases that have allowed those provider agreements to be sold. And, for a potential purchaser, and sometimes the potential purchaser are officers of the old company who found new investors and are going to continue on. One of the positive things about being able to buy this is you can start invoicing and billing much sooner, almost immediately, and receiving reimbursements for services provided versus going and getting your own provider number. So the ability to sell in these recent cases has been really important. One of the drawbacks traditionally is that if you buy this outside of bankruptcy, there is a successor liability risk That just means that they can look backwards, and you are looked at as if you're the old company in certain ways. So overpayments and those issues will continue to follow you. These two recent bankruptcy cases allowed it to be sold free and clear, so those numbers didn't have that look back problem with overpayments. So that's a really powerful tool that you can get a court order doing it. This is a federal practice bankruptcy, so those particular cases that I'm talking about were in Delaware, but courts in Florida still continue to look to Delaware and other places because the bankruptcy code is one common code. It's not state by state. And now we get to the Small Business Reorganization Act. This is what I was talking about earlier that made Chapter 11s useful again. It made them useful. It made them much faster. And with the CARES Act, it expanded the definition of what's a small business. As you may be asking yourself, would I be considered a small business? And originally, when Congress passed it, a small business was considered one that had debts of up to approximately $2.7 million. And for a lot of businesses, they fall into that range. But the CARES Act went ahead and expanded that and increased it to small businesses that can utilize this very powerful act are now those with debts of $7.5 million. And the qualification is at least half of that debt needs to be from commercial activities. But if you're a business debtor, that part won't be the problem. Some of the upsides of this is that very early on, you have a status conference with a judge that's going to figure out a way to get everybody on the same page. So at least you're having conversations early. Chapter 11s were starting to drag out where it could be a year and a half, and you're still sitting around in bankruptcy and wondering, when am I going to get out of this? With this new act, you have that status conference early. A plan needs to be on file within 90 days. And that plan is your repayment plan. It's how you're going to treat your creditors. If you have a balloon payment due, you can spread it out over a period of time. So then it's a monthly payment. You can tweak interest rates. You need to, but you get that document on file within 90 days, and I should be back. Okay. So we'll keep going. As I was saying, one of the big upsides of this is that you no longer need your creditors to vote in favor of your plan. This makes negotiating with them far more powerful because at one point in time they could block your plan, and instead what you have to do now is commit to paying your disposable income over the period of 3 to 5 years. Now, what your disposable income is your projected income less your reasonable expenses. And your reasonable expenses can include salaries and other reasonable bonuses and items and things like that you would need in order to proceed as an organization. So it's not one of those situations where you are going to have to essentially work for free for 3 to 5 years. The courts do understand that you do need to pay people in order to get them to perform. As JCPenney, for instance, was able to get approved several millions of dollars worth of bonuses in order to retain some of their executive staff. So courts do understand that. There is a trustee that's appointed in these cases. However, the trustee's goal in this case is to get a plan approved and to help guide that process, not to take control. So it'll be helpful to have that other person in there. So let's talk about license issues. When you're applying for licenses, there is, usually buried within some of the requirements is that you can show that you have some amount of financial stability. And you may think, well, if I file, for assignment for the benefit of creditors, or if I'm having to negotiate with my creditors, or I file for bankruptcy, I'm going to show that I can't perform financially, and that's going to be a problem for me with my licensing. But Congress understood that. They don't get everything right, to put it mildly. But one thing that they did get right is in the bankruptcy code, they recognize there's a stigma with bankruptcy. And I get that. I grew up in one of those households where you pay your debts, you eat your vitamins, and you just overall be a good person. We try to do that, but issues happen. And that's why in the bankruptcy code, there's specific provisions that prevent discrimination based on your status as a debtor currently or in the past. And honestly, when a lot of these businesses emerge out of after a restructuring, they're better off financially because they've changed their debts in a way that they can continue on. And there are some court cases out there that found that the state of Florida violated this code when they failed to renew liquor licenses or business licenses after somebody filed for bankruptcy and discharged or wiped out prior fees that they owed to the state. So this should allow people to pursue forward and address some of those license concerns. Up till now, we've talked a lot about bankruptcy, but there are some other options that we'll get into. Assignment for the benefit of creditors, as it says, it's a state court proceeding. One of the nice parts here is that, yes, you do turn over to control to somebody, but you get to select that person. You get to pick that assignee. And what's nice is that you can ensure that there's some level of competence in that person, because they're going to take the reins during the case and continue to operate the business, because the business is worth a lot more when it's continuing to operate versus you have a hard stop, we shut the doors, and all we're selling are shelving, we're selling vehicles. Here you can sell an operating business and go at a court order that says, hey, it's free and clear. It addresses a lot of the problems if you're purchasing something out of this. And there are some assets that you may not even have thought of that can be very valuable. Everything ranging from websites to real estate to those vehicles that I mentioned that can be sold. Now you don't have to file either one of those cases. It's become pretty common for people to negotiate effectively and do a restructuring by reaching voluntary agreements with their creditors. Some of the largest companies, AMC Theaters, 24 Hour Fitness, they go ahead and announce, we've hired restructuring or bankruptcy professionals, and to put their creditors on notice that if you don't want to work a deal with me, that's okay, because I'm going to file this thing that you're going to get a lot less money or a lot less favorable terms than if we can work out something now. So you do have the ability to modify terms outside of bankruptcy. It will require them to voluntarily agree to those versus court orders requiring them. You can also sell assets outside of bankruptcy and assignments for the benefit of creditors. There are some issues. If you have liens on them, then you might require creditor permission. There's some, if let's say you're a purchaser, you may be concerned that some of these old liabilities are going to chase these assets or affect you. So those are some concerns if you're a buyer. And as I mentioned, this can be a powerful bluff or negotiating tool as you're dealing with people. Again, not everybody will need to consider whether to work things out with their own creditors. Instead, what they may be interested in doing is purchasing, as Jeffrey mentioned, expanding their own platform, whether buying real estate, buying equipment and things like that. And when you approach a distressed situation where you can tell that the other owner needs to sell, that you have options. You can buy them out of court. It doesn't require a court order, but you also don't have that court order that provides some of these protections that you get from a bankruptcy or an assignment for the benefit of creditors sale. But there are some some upsides because you can occasionally get discounts by buying out of those scenarios. And if you're a seller, what I recently had some success in doing is a business had borrowed quite a bit of money from 4 or 5 different creditors. And what you're able to do is negotiate with those creditors as part of a sale. The creditors themselves may not be aware that a sale is actually taking place. They just know that they are going to get lump sum amounts of money in the near future. And you can negotiate and have those creditors take less, which offers the seller ability to get some money at the end of it, when it at the beginning may have looked like they'd walk away with nothing. Let's talk about HIPAA and some of the sensitive information that you're dealing with. First, what constitutes protected health information? I'm sure many of you are familiar. It's that information that takes either a paper or electronic form that deals with treatment and medical records of an individual. You know, in a bankruptcy case, sometimes they'll appoint what's called a patient ombudsman, a third party that'll oversee how that information's used. It's not always required. This patient information can be very important in sales transactions because if you're a buyer, you're probably going to want to see some of this information so that you understand if you're going to have a steady stream of income, how many different sources the income comes from. It now could be a good time to evaluate your HIPAA notices, which may give you some exceptions to how you can share that information, which may make it easier for if you're considering selling part of the business or selling all of the business, it'll make it a more attractive target and may increase the purchase price. Now, if you're interested in kind of moving on from a particular business, it's possible in these restructuring scenarios to get a court order that allows you to destroy or abandon those records. So then you at least have a court record out there that provides a level of protection. When somebody asks, hey, what'd you do with the records? Well, I have a court order that authorized me to get rid of them and dispose of them a certain way. So that's another option to consider. Now, you may be wondering, okay, I hear about JCPenney, I hear about Nordstrom and her Neiman Marcus and GEMS and things like that filing these proceedings, but do behavioral health providers do these? The answer is yes. The last 2 years, I think it's coincided with some advertising restrictions, and some are just unique to those certain businesses where there were fights among business partners that increased litigation, or very aggressive landlord tactics that made things expensive. So yes, about several dozen across the country have commenced these, and they found it as a nice way to either sell an asset and recover some money, or buy assets and expand their platform, or to reorganize their own debts and emerge out of it a stronger company. That was Small Business Restructuring Act we mentioned. I think a lot of people will take advantage of that because particularly over the next year, where you can have that increased debt threshold and still you remain eligible. I think it'll probably pick up because it'll be a nice opportunity to increase, make your cash flow go a lot further. And that's kind of what we're seeing right now. So at this point, I'll open it up for questions.
Tommy, I have some questions really quick, Jeff. So let me ask. I'm a treatment center. I represent, as you know, we work together. A tremendous number of all different size treatment centers, right? And here's the typical scenario, which is they are getting squeezed by insurance reimbursements, and we have reason to believe, or have heard, that depending on how this COVID thing lays itself out and how the government responds financially, that some insurance providers, certainly for out-of-network, are going to delay reimbursement and, just checks in the mail kind of thing. It's certainly that may happen even under in-network contracts and otherwise. So the question is, typically when we have clients that approach us with financial situations. It's almost always because they're overextended. They're paying staff, they're paying other employees, they're paying for the costs of what they need to do, medications, rent, everything else, and their entire money stream is tied up with insurance that isn't doing a clawback, that isn't doing an audit. Is just they're just waiting to get paid. And there's really, outside of filing litigation, there's really little that they can do. And all of a sudden they have payroll to make and all these other debts, and they don't want to go out of business. But they're getting pushed to this brink. What are their options, both generally and now, with regard to how to resolve that situation outside of just folding up shop?
Absolutely. As you mentioned, to address the revenue front, you probably are going to either have to very aggressively negotiate with those insurance companies or commence a lawsuit. So the way that you can use restructuring is to address the other side of the ledger, the money going out the door. And the way you can do that is by approaching, now or in the future, approaching your landlords, approaching vendors. Let's say you have food supply vendors, you have other vendors out there, and renegotiating your terms. And in this moment of uncertainty, there are deals to be made with those particular people, because they don't know what their cash flows are going to be going forward either. There's a lot of unpredictability, and you have an opportunity to kind of take advantage of that and strike more favorable deals. And some of them, if you reach out to them, may get a sense of, okay, maybe there's an issue here, and I want to keep this person as a client, and they'll be more receptive, because I don't want somebody who's going to walk away. I don't want them to walk away. I don't want them to close up shop. So those are some options. These assignment for the benefit of creditors, as well as a bankruptcy case, and having the old owners buy those assets out and get a free and clear order. That's an opportunity to strip some of those liabilities off. So that's another option out there. But
Is that something you do, Tommy? It's like if I'm a client and I don't necessarily want to be the one to be negotiating with my landlord and everyone else, is that something that you do for the client?
Yes, I do take that negotiation lead, and I've on more than one occasion had a creditor say, "Hey, I Googled you, or I looked you up on your website, and I see what you do," and they get a sense of, if I don't make a deal now, I could be in a much worse position. So that I do take on that role.
What about also, I've seen in many documents we've drafted, transactional documents, leases, you name it, there's standard boilerplate often in times that says that a breach of any agreement would be, amongst other things, if the provider filed for bankruptcy. So what does that trigger, and how do you work with that, so that, and that might just be your liaison role, so that all of a sudden someone works with you, files for this bankruptcy, and then it triggers all of these contract clauses that I've just breached by filing for bankruptcy?
Right. And while that can be, the bankruptcy courts deal with those clauses by acting in many ways as if a breach never occurred.
Mm-hmm.
Because you can go ahead and modify. Oftentimes what you see is, if you or some other entity files for bankruptcy, then it immediately accelerates the loan, or all the debts are paid, or your lease is terminated.
Exactly. Right.
But bankruptcy courts generally don't enforce that, and instead the contract release remains intact, and you retain that ability to modify it. Um, so people put those clauses in there, and I'd say here's where they can be problematic for you, is if it says, if one business owner files for bankruptcy, but the business itself doesn't file, then that can be an accelerating event. So that's why you kind of want to be in communication and timing. Um, and some, some lenders or others won't enforce those if you kind of make clear what's going on and you strategically bring them in to the conversation. And that's something that I do as well. You have to make timing matters, and having that conversation a certain way the first time matters.
And what's the best time for someone, they're not thinking of bankruptcy, they're not thinking of restructuring, but they're trying to just get their ideas of what their options are. When in the revenue cycle or business cycle of this is the best time to engage or speak with you or someone who does bankruptcy and restructuring?
Sure.
Obviously not till it's too late, but if you do it too early, then it's kind of like people don't necessarily want to spend legal fees to be told what they can do later. So how does that work out? When is the time when you go, look, now is the time where you need to become speaking to someone in bankruptcy and restructuring before it's too late?
Well, for some people, when times are very good and revenues are high, that can be an opportunity to come in and talk about their options as far as, hey, not everybody's doing so well, and it's an opportunity to buy assets. And the alternative is when things are going really well, that's when you can get creative from a planning standpoint and protect more assets if things go poorly. And that's something that can be assisted with also when things are going well. Um, for instance, you may, if you have one company that owns all the assets, including the real estate, it may make sense. Hey, things are going really well. We'll have a different company that owns the real estate, and there's a lease scenario. There's things you can do creative when things are going really well. Now, if you start to hit a hiccup or you see issues on the horizon, that's another time to come in, see what your options are, because it may impact how you litigate that problem or how you deal with that creditor. You may tell them to pound sand, or you may look at your options and say, oh, I need to figure out how to pay this one to go forward.
Now, before I'm asking the question, but before I do so, everyone, you can see the bottom of the screen. There's a Q&A button. If you click on that, you can ask a question. It'll be answered anonymously. Or if you want to just email us, you can see on the screen our contact information. You can always email us a question and give us your contact information, and we'll call you back. Tom, I got one last question, which happens frequently with our clients, is they sign a lease. Treatment centers often don't own very much. They don't always own the land where they're located. They have a lease. If they have recovery residences, those may be leased. They don't own many assets. The only assets they own is really their accounts receivable and personal effects. Many times in a lease situation, especially with a new tenant, you're going to have a landlord's going to make the tenant sign a personal guarantee. And so, what do you do with a treatment center program that is going out of business, but there's a personal guarantee signed by the CEO? Does the CEO need to hire his or her own lawyer to try to get themselves out of that personal guarantee situation on a lease?
Okay.
Or
So
can you handle both? I guess is the
oh,
question.
right. There are a couple good points. One thing to do now is to either yourself or with professionals, go ahead and look at your leases that you have, because in those leases you may have very smartly negotiated for options to extend your leases, but those options may require you to provide notice to your landlord within a certain amount of time. So don't burn those options. Go ahead and start reviewing those and considering those, and bring, if you need somebody to review them, bring that person in to review them. Now, oftentimes it is the business owner that comes in and says, my business has a problem, and so do I, because I did have to sign a personal guarantee. So what as part of the representation, I'll make clear that you do have to generally pick either the business or the individual. But if you're approaching as the business first, it is not uncommon to negotiate uh, to also eliminate or limit guarantees as part of whatever deal you're reaching. And in bankruptcy cases, as well as assignment for the benefit of creditors cases, what you can do is you can get a court order that prohibits that person from being sued so long as they contribute to a settlement. Here's kind of the common scenario is you have a person that has a bunch of personal guarantees or is subject to lawsuits because people are trying to go straight after the individual. The business files for bankruptcy and it settles those claims, which it has the power to do with that officer. And as part of that, it gets an injunction and a release for that officer. Now, that officer may have to contribute some amount of money uh, towards the bankruptcy case individually, but that amount of money generally will be far less than if the full personal guarantee was pursued. So to kind of answer your question, yes, we generally can initially go in on behalf of both and try to resolve the issues that both are facing. If ultimately a case is filed, then it's possible that the individual may need to get separate counsel to represent them in the bankruptcy case.
Okay, Tommy, thanks so much for your time today. If there aren't any other questions, now's your chance to ask it. Not seeing any, you can please feel free to share information. And this was just meant to be a teaser of information. The concept and subject matter of bankruptcy is long, and we also don't want to scare anyone with the word bankruptcy. Remember, it's all about reorganizing your business to stay solvent moving forward. The word, the bankruptcy has a negative connotation, but it shouldn't and it doesn't. It's simply a way that, one of the few countries, but the United States tax code, bankruptcy code allows people to restructure their debt rather than simply go out of business. And certainly during this time right now of the COVID crisis and for however long this recession, depression is going to last, it's certainly going to be, there's be laws that are going to help small business. Luckily, we've seen that treatment providers are doing very well. Certainly, addiction doesn't know recession. Addiction certainly reacts to times like now in a way that's negative for the patient, but economically it's positive for the provider. So they now also need to use this opportunity to fill their beds, treat these people certainly who need their help, but don't overextend themselves. But I think that you're going to see an uptick in treatment demand for quite a while. So now's really the time to strongly get out with a business plan, but don't overextend yourself. And if you do overextend yourself, that is what reorganization and restructuring is for. It's not a punishment. It's actually like a free hallway pass. So anyway, Tommy, I want to thank you for your time. Any last closing statements from you, Tommy?
And as those people are, as treatment centers are doing well, now can be a good opportunity to pick up assets and grow as well because others, whether it's real estate or other opportunities may become available to them, and we can help navigate that as well. Thank you for everyone's time, and I truly appreciate it. Thank you, Jeffrey.
We'll be doing more of these in the future. Absolutely. If there's a specific subject that any of our attendees today would like to hear, please pass that along. And we look forward to talking to everyone soon. Thanks again for joining us and have a great week. Bye, Tommy.
Bye.